If you are injured on the job, your rights are determined by the workers' compensation statute. Workers' compensation is different from an automobile accident, slip and fall, or a medical malpractice situation. If you are injured on the job, fault is not an issue, which means that you don't have to prove that anybody did anything wrong in order for you to receive benefits under the workers' compensation law. However, under Florida workers' compensation law, as an injured worker, you are limited to what you can receive, regardless of who is at fault. You are only entitled to receive benefits which are in the statute, which are basically medical bills and lost wages. Here at Farah Farah, we've been helping injured workers for many years. What has happened, however, is that the legislature, because of pressure from big business, has over the years eroded and reduced what the injured worker is entitled to receive. Investigating your case at Farah Farah, there are many things that we look at when someone comes to us with a workers' comp claim. We look at how the accident happened. Were there other parties involved? Is there another person who contributed to your injuries? Additional compensation. There are situations when we have been able to help people injured on the job to recover over and above what they may have been entitled to under the workers' compensation law. Let me give you some examples. If you are injured on the job and some third party causes your injury, and if that third party is not your employer, you can still make a workers' comp claim and pursue your claim against that third party for your pain and suffering and all the other damages that you'd be entitled to collect in a typical negligence case. For example, perhaps you're driving a delivery truck and you're on the job. At that time, another person runs a red light and hits you. You'd be able to recover your workers' compensation benefits, plus you'd be able to make a claim against the at-fault driver. So we're always looking for a potential third-party case at our firm to see if there's another way for our clients to get the recovery they deserve. Another situation could be if there is a defective product that caused your injury. Maybe you were working on a piece of machinery that caused your injury. You'd be entitled to receive your workers' compensation benefits, but at the same time, you'd be able to proceed against the company that made the machine or the product if the product was defective. One of the most recent attacks on injured workers' rights occurred back in October of 2003. For instance, under the old law, the injured employee had the right to an independent medical examination with a physician of his own choice, and at the expense of the carrier. The claimant, when dissatisfied with the opinion of an authorized physician, also had the choice to change physicians with another network provider, and was given the choice of another network provider under the medical discipline contested. Under the current law, the change of a physician will be granted only one time throughout the case, but with a physician exclusively chosen by the carrier. Another change was that the standard for permanent total disability was made more stringent, with the injured worker now having to prove the inability to perform sedentary work within 50 miles of his home, as opposed to showing eligibility for SSD benefits. The psych impairment rating is now limited to no greater than 1%, and a psychiatric disability cannot be paid for more than 6 months after reaching physical maximum medical improvement. 104 weeks of temporary benefits include 52 weeks for retraining, whereas before, the 52 weeks of retraining was on top of the 104 weeks. The majority of permanent impairment benefits paid after reaching maximum medical improvement are reduced from 3 weeks per percentage point down to 2 weeks. The burden of proof has also been made more difficult for the injured worker, in that he must prove that the injuries resulted from an on-the-job accident. The new statute has also limited injured workers' access to the courts. Under the old statute, if there was a wrongful denial of benefits, your attorney would be able to have his attorney's fees paid by the insurance company, the time he spent litigating that issue and winning that issue. Under the current statute, fees are generally limited, which means that a lot of lawyers don't find it financially reasonable to handle workers' compensation claims. Attorney fees have been reduced to a statutory formula as opposed to being based on the efforts of the counsel to secure payments, thus limiting access to the courts. More insurance companies are denying more claims, knowing that it's very difficult to get a lawyer to fight because of the limited compensation an attorney can receive. Every time we receive a workers' compensation claim in our office, we look at all the different possibilities to try to get our clients the compensation they deserve. There are several ways that you may be entitled to benefits over and above what the compensation law allows. If a coworker injures you and that coworker's job responsibilities are different from yours, for instance, perhaps the other coworker works for a different supervisor or maybe has a different job description, you may be able to make a claim against your employer over and above your ordinary workers' comp claim. As of October 2003, if your employer creates a job environment where it is a virtual certainty that you will be injured, for example, the work conditions are very dangerous, you should be able to overcome the workers' comp immunity and make a direct claim against your employer. To sue your employer, you must prove the following: your employee's knowledge of the dangerous condition, evidence of concealment or misrepresentation to the employee, failure to take reasonable precautions to protect the employees, and absence of warnings, training, precautionary measures, safety equipment, physical evidence of dangerous conditions, prior accidents and complaints by employees. If these situations are present, you may be able to defeat the workers' compensation immunity and pursue your claim directly against the employer. However, you must be careful when handling your workers' compensation claim. If you pursue your workers' compensation benefits, you may be precluded from maintaining a separate claim against your employer. That's why it's so important to talk to an attorney who handles these types of claims, so he can properly advise you of your course and direction. Just because big business and the insurance companies keep trying to reduce injured workers' rights, this isn't going to stop us from working on these cases, and we'll keep handling them until they nail the doors to the courthouse shut.